All right, so are you Brandon Lewis Chillo? And is it Chillo or Chalo?
Shallow.
Shallow. Mr. Shallow was previously in court. Well, first on probation in two cases, clause numbers 19-32303, excuse me. Yeah. 19-32403 and 19-32404. Both of those for sexual assault of a child. Those are both 10-year deferred probations. There was a motion to revoke probation filed, and we were previously here. Mr. Shiloh pled true to counts 1 and 2 in both of those motions, which alleged, get to it real quick. All right, so count 1 pled true that he did not successfully complete the sex offender counseling and was terminated from that program. And then count 2, he pled true that he possessed sexually stimulating or oriented material on his phone in violation of the order. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Is that dated January 26th, Your Honor?
It is.
Yes, I've received it as well.
Are there any additions or corrections to that updated report?
No,
Your Honor.
no.
All right, and then so attached to that also, part of that report was the letter from Julie Ayala, who is the sex offender counselor. That was dated July 25th of 2025 with the specifics of why he was terminated, I believe, from that counseling and treatment program. You've seen that as well, correct?
I have.
All right, Mr. And that there was no agreement for any type of punishment in these cases. And so, Mr. Lewis, you may proceed.
Yes, Judge. Judge, we are asking that Mr. Chalo be allowed to continue supervision with some amendments to the probation. I know one of the things that even probation even recommended or suggested in their report, of course, the cognitive track of ISF. We think that will be be very appropriate in this situation. I have had talks with Mr. Shiloh about the violations as well as basically this situation. And he's been very clear to me as far as him understanding how serious they are. But I think that the cognitive track will be able to enhance or basically really enhance that thought process for him. To not minimize any of these situations or requirements from the sexual offender program or just probation in general. Understand that it is all very important, unless or it wouldn't be a requirement of it. And he's more than willing to comply. The situations that led into these violations here, it was a situation where, given how they happen for a situation, the information on his phone or through the polygraph situation, a lot of that dealt with, communicates with him and a loved one of his. And he had to understand that even those type of situations, it has a determining factor. It can be a determining factor dealing with his probation. And after, and him realizing, recognizing that, he knows that, hey, there's certain things he just can't do. Like, I'm not saying he thought he could do them, but he knows now just how imperative, following every violation of rule or their sex offender.
So one thing I didn't say, and I'm sorry to interrupt,
Okay.
but in addition to those 2 10-year deferreds, the plea agreement on this case was different and kind of a hybrid.
Right.
Back when we did this, and there was, in addition to the 2 sexual assault of a child cases, there was also an improper relationship between educator-student case and an online solicitation of a minor. Those 2 cases, he was given 6.5 years in prison. So went and did some amount of time in prison,
Right.
then got out and on probation.
Right.
So I can, and Ms. French, I'll give you an opportunity in just a minute, but it doesn't make any sense to me that 90 days in ISF would do more than a 6.5 year sentence in prison to make it clear to Mr. Shallow how serious it was that he got out and followed the rules on probation. That was all gone over when he was given probation.
Vo has hone. Did you catch the judge's reaction there? That was the moment this hearing shifted from rehabilitation to public safety. The defense is arguing for another chance. But the court is looking at a man who already received probation, prison time, treatment opportunities, and still came back violating the same core conditions. In courtroom language, that's a credibility collapse.
The fact that he got probation, this was a young person who was in middle school that, it's, anyway, I just don't think arguing for me to leave him on probation is probably where you need it.
Okay.
It doesn't make it, the browser history, the titles of the things that Mr. Shiloh was looking at all have to do with teen pornography. So clearly, the most important thing is that he follows through and with treatment, because he's exactly where he was when we gave him this opportunity back then.
Mhm.
So, Ms. French, your position?
Yes, Your Honor, and just because it's the way I'm used to doing things, I would ask the court to take judicial notice of both of his pre-sentence investigation reports, since I'll be referring to them
Sure.
both. One, the date of the report, January 26, 26, and the first one, May 12th of 2025. And I, just to add to what the court has noted, Mr. Shiloh was placed on probation on May 5th of 2021 in this case. He went 30 months without any notice of a violation that caused an MTRP. But then in January of 25, 7 violations were noted, including a DWI offense. He pled to 5 of those 7 violations: failure to remain in Jefferson County, the new offense, failure to report new arrest, curfew violation, failure to pay court-assessed fees. That was not even a full year ago, Your Honor. He signed, as far as I can see, and I would ask for judicial notice of this as well, that in both of the probation orders in these cases, 19-32403 and 404, he signed an understanding as to the conditions of his probation. It is this prosecutor's opinion that it was by grace that he received probation in those cases. And yet, less than a year ago, he pled true to 5 of 7 violations. Now he's pled true to both allegations in the MTRP that was filed.
What was the outcome of, I'm trying to look back and now see, of the motion,
It appears to
or
me.
was there a motion?
There was a
motion?
motion filed January 10th of 25, and there was a hearing
Okay.
where he pled true to those
I
violations
see that.
on March 24th of, I'm sorry,
April 29th.
correct. And then the MTRP was dated January 26th for a date of sentencing of March 3rd. So, okay.
So what did I do
It looks as though
in that first motion?
on June 24th of 25, there is an order that he enter and successfully complete JCDI and return to the sex offender caseload upon completion. And I
Yeah, I see
believe
that.
he was also, and I'll ask my son, is that when he was also assigned to go to the sex offender treatment program?
He was assigned at the beginning of his probation.
Yeah, that came from the beginning.
Okay.
Okay, thank you. Now I see this. So this is the second motion
Yes, ma'am.
to adjudicate in these
Correct, Your Honor.
cases. When does anybody, and Ms. Simon, maybe you do, have the date when Mr. Shallow was released from prison?
Back, like originally,
On the two, so he got 6.5 year sentences on those two, the online and the solicitation and the improper education student one. Two.
22, September of 22.
September 9th.
So something nice, sure.
Okay, so you did roughly a year and a half. Ish.
In prison,
Hmm.
3.5 years. From 19 until September 9th. So it was
No,
three-
in actual prison, not in our jail.
prison, yes, I did about a year and a half.
Okay. Okay. So you parole, so you're on parole now still, or are you off?
I complete parole April 27th next month.
So you're still on parole?
Yes, ma'am.
Yes, ma'am, next month.
Okay, got it. I'm sorry, Ms. French, I just want to get all that straight. Go ahead.
I noticed in the interview on this latest PSI that it states interview with defendant during a jail visit on January 20th. And I believe that Ms. Simon was at that jail interview.
There was another officer in my place that day.
Okay. It says that Mr. Shiloh made statements such as, I learned I need to be more careful and ensure my phone is clear.
And this right here is devastating for the defense. Saying, I learned to clear my phone better, instead of, I learned to stop searching, this content changes everything. Prosecutors love moments like this because it suggests concealment, not rehabilitation. That single statement may have done more damage than any evidence introduced today.
That is not, I've learned that I need to stay away from websites such as, I hesitate to even
got 'em.
state them on the record, Your Honor, in the report by Julie I'm sorry,
I got it.
Ayala. This is 5 years later, from May 5th of 2021. We're almost to 5 years later, and we're here for the same thing. He's been to prison. He's had an opportunity to follow your orders under the adjustment that was made in May of 2025 and the following orders of June of 2025. And it just keeps going. I note that under recommendations that Mr. Shiloh remains a risk to the community, according to this PSI, and the state would agree. The state does not believe that any GPS monitoring device would prevent what continues 5 years later. Our children are the ones who are at risk because his victims were not adult women, but a 15-year-old child. And it looks as though that's the same kind of pornography that was found on the phone. So it's the state's position that his probation should be revoked. And if this is the correct time, it's my first sentencing hearing in your court. The state would ask that these sentences be stacked under Penal Code 3.032A, because these are these adjudications are under 22.011, sexual assault of a child. It doesn't matter if the victim is the same. It doesn't matter if it's in the same criminal episode, that the code allows us to stack these sentences. And I would further state that even though the agreed punishment recommendation was for 10 years deferred and that the sentences would run concurrently, that agreement was based on the fact that, or the idea that he would be successful in his deferred adjudication. Certainly not that he would continue offending in a sexual manner. I think it's safe to say that even if you're looking at pornography involving a child, you are offending against children in that way. And so whatever this court determines is a proper sentence, the state asks that the sentence in these cases be stacked.
My My issue with them being stacked is that that original plea agreement was for concurrent sentences. And so I think based on that, legally, I'm not real sure that that is something that would be available to the court. Because it was negotiated at that time. It didn't say concurrent unless certain violations or things like that. But I certainly agree with many of the other issues. Anything else, Mr. Lewis?
Judge, not from me, but Mr. Shiloh does want to address the board
All
before.
right, go ahead, sir.
No, how are you, Ms. Willis, Your Honorable West? I just want to say that I take my probation very seriously, and I also do take responsibility for, what was discovered in my phone. I have taken great steps to progress in the things I've done since I've been released. I've always been on time, always complied with what was asked of me in probation. I've never missed my sex offender class. I've paid my fees. I've completed my community service. Anything that's been asked of me, I've gone above and beyond to do that.
Not anything,
That's fair, yes, ma'am.
not anything.
Yes,
The
ma'am.
most important thing you haven't done.
Yes, ma'am.
The most important thing.
And-
And I think, well, let me just stop you. I'm going to do this.
Listen to the tension building in this courtroom. The defendant is listing fees paid, classes attended, and community service completed, but the judge keeps steering back to one issue: treatment failure. In sex offense probation cases, judges often care less about checking boxes and more about whether the underlying behavior has actually changed. And from the court's perspective, it clearly hasn't.
That you have not taken advantage of what treatment you should have gotten to this point, and puts, in my opinion, every young person and girl in our community at risk. You're 40-something years old at this time. You were 37 when you had sex with a 15-year-old and did all of this. It's not like this is you're 17 and they're 14 kind of thing. This is a true, in my opinion, predator on young girls. And so for that reason, at this time, I'm going to find that you entered your pleas of true in each of your cases freely and voluntarily. In cause number 19-32403, find sufficient evidence to find you guilty, and at this time find you guilty of sexual assault of a child. Sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 19-32404, also find at this time sufficient evidence to find you guilty and find you guilty of sexual assault of a child. Sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently. If I could stack them, I think I probably would, but
20 years. Concurrent, not stacked. That distinction matters. If the sentences had been stacked, he could have faced decades longer behind bars. But even while explaining the legal limitation, the judge practically says out loud that she would have stacked them if she legally could. That tells you exactly how seriously this court viewed the danger to the community.
I don't think legally that is something that is at my disposal. So they will run concurrently. I am going to hand you the trial court certification that shows this was not an agreement. You'll get a copy of that. You do have some rights to appeal. You can talk to Mr. Lewis about that. I need both of you to sign that, and then I'll give you your copy. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Sir?
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. You can go back with the bailiff. Thank you. That's for him. And you.
And Your Honor, next time I make the request, I will know whether or not it's within your
Thank
authority
you so
to
much.
do it.
I appreciate that. And Mhm. Good morning, ma'am. Were you Angela Reyes?
ma'am.
And Ms. Reyes is charged in cause number 26 DCCR 0264 with assault on a peace officer, 26 DCCR 0265 with the obstruction or retaliation, and 26 DCCR 0266 with assault on a peace officer. Those offense dates are all from December 22nd of 2025. It looks like the cases were indicted February 11th of 2026. And so, Ms. Reyes, let me just get everything straight first. Were you released on accusation when you first got arrested on these offenses?
Yes, ma'am.
And then the indictments came down and there were warrants and you went back into custody,
Yes, ma'am.
correct? Mike can tell, but do you remember the date that you went back into custody?
I know it was Wednesday last week when they picked me up on a warrant from my
Okay.
house.
So was it? Okay. The 25th, February 25th.
Yes, ma'am.
This shows when these were executed. You were magistrated out at the jail that next morning, and it appears as though the magistrate set the bonds at $10,000 for the 2 assault on a peace officer charges and $8,000 on the obstruction charge. The district attorney's office has filed an Article 17 objection to that bond, asking that I increase the bond. Have you been arrested for anything? Well, let me do this first. Raise your right hand the best you can. You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay, so from the date of these offenses in December 22nd of 2025, have you been arrested for anything else?
Since December?
Yes,
No,
ma'am.
I have not.
Okay,
And this is my first like big I've ever.
these are your first felonies?
Yes.
And Mr. Coleman, you're shaking your head. Do you agree that there's nothing in your file that shows that there's any felony criminal history?
I agree.
Okay. Let me do this real quick because typically this review is going to be it's a new type of thing, a law that has been handed down for the district attorney's office and the courts to review certain bonds that the magistrate set. But typically that is going to be when you're on bond for one felony and then another felony is alleged to have been committed, which we don't have here. And so let me take a quick look at the probable cause in these cases, and then I'll let you guys kind of know where I stand on it. And Ms. Reyes, have you ever had any type of mental health assessments or counseling, or are there any issues that go on that you have going on that you feel like you would need that?
I will say a year ago in February, I survived a suicide attempt, so I had to get hospitalized. And that's where they did evaluations and diagnosed me with depression. So
Now the courtroom energy completely changes. Compare this hearing to the previous one. Instead of punishment dominating the conversation, the judge immediately starts asking about mental health, medication access, housing stability, and treatment options. This is a perfect example of how judges weigh risk differently depending on criminal history, circumstances, and the likelihood of rehabilitation.
I've been off my medicine because my insurance lapsed because I just had a baby in September, and I haven't been able to take it since I started getting back on it whenever I went into custody. So they set me up on that.
If you make your bond as it's set now, or depending on what it is, where would you reside?
With my father and my 2 children at the 7515 North Major.
Okay. Well, that's where you were when they came to get you and arguing with your dad. Is that correct?
It was with my fiance. It was virtual.
Okay. you were arguing with your fiance, or your fiance was arguing with your dad, or who was arguing with who?
It was me and my fiance, and then my dad was the one who called the police.
Okay. Where would your fiance be living?
He lives there too.
Okay,
also.
so here's where, at least while this is pending, there could be some issues. Well, Mr. Coleman, I guess based on where I've gone kind of so far with this, what is your position with regard to the motion that
Yes. Just,
your
we-
office filed?
We'd simply just ask that the court give the motion its due consideration, and
Okay.
certainly we defer to the discretion of the court.
Mr. Lewis?
Judge, well, I had conversations with Ms. Reyes' father, who was there, and the one who called the police. And as far as a bond goes, my conversation with him was that even the amount that is set could be a stretch for them to try to make. And also, like I said, with some of the issues that she was already having, part of that was her not being able to have her medication because it was a financial issue. So, of course, we'll be asking that the bond remains as the same. But like I said, if they are able to make that bond, that would definitely be an amount that, would definitely ensure her return to court and, well, any public safety issues.
All right, then here's what I'm going to do. At this time, I'm not going to raise your bonds in your cases. I'm going to deny the state's motion to raise those bonds. I am going to make a condition of the bonds, if you make them, that you make appointment and go to the Spindletop Center for treatment, medication, assessment.
Yes, ma'am.
They will work with you without insurance. And so it's going to be a condition of your bond that you do that.
Go do
So
that.
you need to make sure if you make your bond, that when you make that appointment, you get that appointment to Mr. Lewis and your bondsman, so they know you're following through. So I know you're following
Oh.
through. And that's really just meant, if for me to order, it means that they should be able to help you more
Yeah.
because it's a court order.
Mhm.
And so there's no reason for you not to go do that. And
Yeah.
now, if you don't do it, it'd be a violation of your bond. And obviously at that point, Mr. Coleman might have more to say than he did today. And we would have some concern about some of the same behavior, and I would have no choice but to raise those bonds. Do you understand?
Yes, ma'am.
Okay, all right, you can go back with the bailiff.
All right, thanks,
Thank you.
thanks, Jeff.
Yes,
The other one's
sorry.
into our hands.
Nope, all good. All right, ma'am, are you Lee Coney?
Yes, ma'am.
And so we've got two cases here. We've got 25 DCCR 1274, which is a new offense. And then there is 24 DCCR 1600, which is an MTRP. We were previously here in the motion to revoke case. And we were set for a hearing this afternoon. And Miss Coney, was previously here and entered pleas of true to count 3, 4, 6, and 7. Got an updated pre-sentence report. First of all, have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, we have.
Okay, any additions or corrections to that?
No, Your Honor.
Not from the sentence.
And so what I'll do is let's go through the new case since there's an agreement, and then I'll go through the sentencing and that MTRP so that I know exactly what's going on. And will she waive the formal reading of the indictment in the new case?
So moved.
Ms. Coney, in cause number 25, DCCR 1274, you're charged with the state jail felony offense of possession of a controlled substance from September 12th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Kimler?
Yes.
Do you fully understand them? And do you understand, if I follow this agreement, that you will be waiving or giving up any right to appeal?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
And it looks like the agreement that you've reached is for a 20-month term in the state jail prison. And the state would run concurrently with that motion to revoke case in cause number 24 DCCR 1600. Also, the state has agreed not to file cases that are that have been, I guess, received but not filed yet on an offense date of November 1st of 2025. Is that
Have
correct?
not yet been received, Your Honor. The
Okay.
labs are pending.
Okay, same types of offenses.
Yes.
All right, is that your understanding of the agreement? State tenders number one,
Without objection.
it's admitted. Is there any evidence that Ms. Coney is not competent?
Not that I'm aware of, Your Honor.
All right, ma'am, and cause number 25 DCCR 1274, I find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with that agreement to a term of 20 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And so then there was no agreement in cause number 24 DCCR 1600. Is it the, I guess, recommendation at this time that I sentence her in accordance with what that plea was?
Yes, Your Honor.
So the 20 months would
20
be the,
months
so,
concurrent with 1274 and refuse the two, which
Gotcha.
I anticipate to be state jail and Class A.
okay. All right, then, based on that, then Ms. Coney in cause number 24 DCCR 1600. Well, let me ask you, initially this was unagreed, and so there was a right to appeal, but it sounds like there's now an agreement and some things that the state has done and given, I guess, in exchange for that. And so is it your understanding, and do you want me to follow that agreement now for a 20-month term in that motion to revoke case?
That's correct, Your Honor. She waives appeal.
So I am going to have you sign a document that shows that this is now a plea bargain, and so you've waived your right to appeal, and then I'll go forward.
So. Let's see. No.
All right, so then I'm going to find that you entered your pleas of true to counts 3, 4, 6, and 7 freely and voluntarily. Find those counts true, and at this time find sufficient evidence to find you guilty and find you guilty of theft of property. Sentence you in accordance with this new agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run together consecutively at the same time. The state agrees in both of those, not concurrently, I'm sorry, concurrently. So they will run at the same time. And the state will agree to refuse the two cases from November 11th of 2025. I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed. And so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right, thank you. Good luck to you, ma'am. Thank you, Mr. Kimler. Thank you, Ms. French, for y'all discussing that and working it out. Good morning. Are you Donnie Smith?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Hello, Your Honor.
Mr. Smith, in cause number 26, DCCR 0072, you're charged with a second-degree felony offense of assault on a peace officer from December 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any type of any right to appeal?
Yes, ma'am.
And so I see it's just marked off community supervision, but nothing
So
else.
we're unagreed as to the type. The state is recommending straight probation. We're recommending deferred.
And leaving the type and the amount of time
Yes.
up to the court. So I want to make sure you understand that the agreement is that you get a probation. The type of probation, whether it's straight or deferred, will be up to me at sentencing, and also the length of time that you're on probation and any conditions, and any fine in addition to that. Do you understand?
Yes, ma'am.
And you have an absolute right to have a jury come in and determine if you're guilty or not, and you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Ms. Malfino, what is the state's position with regard to a bond reduction based on that plea?
Judge, in reviewing Mr. Coleman's notes in this case, it doesn't appear that this young defendant has any substantial criminal history, just so the court is aware of pending UCW and evading also arose out of this incident. And so it's obviously concerning to the state that a weapon was involved, but I've heard of what you think is appropriate, unless Mr. Coleman has additional to add.
Nothing to add to that. Thank you.
Thank you. All right, Mr. Smith, what I'm going to do based on the nature of your plea agreement is reduce your bond in your case to $2,000. If you make that bond, there's a couple of very important things that are going to go along with it. One, the very first thing you do is go straight to the probation department so they can start that process to get that report done for me. If you don't,
This is one of those courtroom moments people misunderstand all the time. A reduced bond is not the same thing as getting off easy. The judge is basically saying, I'm willing to give you a chance, but one mistake between now and sentencing could destroy this deal completely. That's why the warning about firearms and new arrests was delivered so directly. The defendant is walking a legal tightrope from this point forward.
do that, then you run the risk of me not accepting the plea agreement. Things could be much worse. Do you understand?
Yes, ma'am.
Also, if you make that bond and you are arrested for anything between now and when you come back, you obviously run the risk of me not accepting the agreement. You understand that as well.
Yes, ma'am.
In addition, I'm going to order as a condition of that bond, you are to have absolutely no possession of any firearm. Okay.
Ma'am.
That means you can't be in a car with someone else that has a gun. You cannot be in a home where there are guns. You cannot be around any guns until further sentencing. We'll figure that out depending on what's going on with that misdemeanor case. Do
Yes,
you
ma'am.
understand? Any other conditions that?
No, Jill.
All right, then we will see you at sentencing. You can go back.